Well, thank you very much indeed. Thank you, Lucy. Thanks to all the organisers, Doug, Flutura, Talach, to Sylvia and the Council of Europe for hosting us. It's really great to be here. It was great to walk in this morning and see so many friends. It's very exciting to be at this gathering of some of the leading experts of the media freedom community around Europe, and to be here to talk about our relationship with the European Court of Human Rights. In that context, it was rather amusing to hear Judges Shio and Spano kind of handing the gauntlet back to us this morning and saying that it's we that have to, at the end of the day, defend the, or define the higher values that these judge prophets should be defending. And as Judge Spano said, that the culture of human rights, the ultimate front line has to be the national level rather than the backstop of the European Court of Human Rights. I guess that's something that we should talk about. Perhaps that's exactly our challenge. Perhaps that's why we're here at this point in time, which is that the national authorities are not doing that. They're not playing that role. We've heard this morning over and over again from around Europe, from Barbara, Galina, Jill, Sana, from Yaman, had he made it, that it's quite the opposite that's happening. And that's in the area of defamation, but it's in other areas as well, including the area of the right of access to information where I work. I'll come back to that briefly. We've heard in detail about, just now, thank you, Lawrence, for setting out that case for us. We've heard about the advances at the European Court of Human Rights. It's terribly important, and while the judgments might be imperfect, and while amongst the different people gathered in this room we can have debates about the nuances of different judgments, I would say we need to recognise overall the incredibly positive role that the European Court of Human Rights has played in advancing and defending our fundamental rights in the area of freedom of expression, and indeed, eventually, perhaps slightly lagging behind other international human rights instances, like the Inter-American Court of Human Rights or the UN Human Rights Committee, recognizing, permitting us to develop this as a right, the right of access to information. And that was something that I was thinking. I cycled along here this morning, following the signs for the European institutions, thinking about everyone meeting in Rome tomorrow to celebrate 60 years of the European Union, and recognizing that the Strasbourg institutions are even older than that. And thinking about the importance of this. And it is a complex interplay between the national and the supranational level that we have. On the positive side, it's worked very well thus far. As Sylvia Gunman pointed out this morning, the Council of Europe has helped nudge this along with its standard setting. Standards that have included, in the realm of the right of access to information, the 2001 Declaration on Access to Official Documents and the 2009 Council of Europe Convention on Access to Official Documents. Nudged is the word I use because it's not going incredibly fast. The Tromsø Convention on Access to Official Documents is not yet in force. It's only had 9 of the requisite 10 ratifications to enter into force. Many of them are smaller countries around Europe. It's not the bigger countries. France, Germany, the UK, perhaps not so surprising, haven't ratified. It's the Nordic countries plus a handful of the newer democracies. And that's an issue because whilst things are moving forward, they're not moving forward incredibly fast. And then that's in the context of the legal framework. But then if we look at transparency in practice, I would say it's nothing like as impressive as even the standards and the laws might lead us to believe. Access Info has just done a pan-European survey of the information needed to follow decision-making in 11 countries plus the EU level, and we found that in most cases we can't get information. I'm not only talking about sensitive decisions, although we've found particular resistance when it's decisions like how to solve the economic crisis or address the current context of refugees and migrants, but even with less sensitive decisions, less than 40% of the information that we were looking for was available. And it's in that context precisely that we have leaks. And that's why it's also very important to protect the whistleblowers. And that's the connection between the right of access to information, freedom of expression, and the whistleblowers. Because we still don't have, in spite of all the progress made, in spite of the recognition by the Strasbourg court, eventually, of this right, we still don't have sufficient levels of transparency in practice. The question that we have now is to what extent are we able to continue advancing this? How do we maintain the virtuous circle that we could perhaps conclude that we've had so far? A virtuous circle in defence of the rights which are absolutely essential to open societies. How do we do this in a context where many governments around Europe are putting the brakes on, if not driving pretty fast in the other direction? Indeed, not only in Europe, but around the world. I don't think I need to say right here how serious this challenge is, but just to note that it's not only the traditional bad boys of the Council of Europe, but it's many others as well. I've just spent 2 days in Paris with the steering committee of the Open Government Partnership, and we were talking more about how to prevent closing of societies rather than how to advance opening. And that's the reality of where we are in 2017. So what I hope we can do is get down to the practicalities of what we do in order to protect the rights that we've managed to achieve so far, as well as advancing them. I'm going to finish with 3 challenges, 2 substantive and 1 more general and strategic. The first substantive challenge is this question of privacy. We've just heard from Lawrence about how the Hungarian court tried to say that the information that was being sought by the Hungarian NGO was actually private data. We heard from various people this morning talking about how there is now a tendency to, in lieu of selecting a defamation suit, to go for protecting one's privacy, because that may be, there may be more chance of actually shutting down access to information, limiting freedom of expression by those who don't want it to be exercised by use of the right to privacy. We see this very much in the realm of access to information. Lucy, you mentioned our campaign for expenses of we were looking for the travel expenses of the commissioners of the European Union. And the first response that we got from the European Commission was that we could not access this information because it would damage the privacy of the commissioners of the European Union, because the data includes the names of those people, which is their personal private data. Now, at an absolutely strict definition level, that is correct. And there we have a problem, because we have 2 rights, and often we haven't mapped out the articulation between those 2 rights, and we see it at the level of the European Union and in many countries that we're denied information that we could conclude really should be in the public domain on the grounds of protecting privacy, which includes the names of the people involved. We need to work that out. There are questions of how we do that. Do we do it through the job titles that those people have, their positions, or do we do it somehow through the functions that they perform and the role in a democratic society? To give you another example of that, Antoine, you mentioned that the European Parliament, subsequent to LuxLeaks, Panama Papers, etc., is looking at amending the 4th Anti-Money Laundering Directive to create registers of beneficial ownership. They are doing that, but the question is, will those registers of beneficial ownership be public? There's a huge pushback on the grounds that that is the private data of the owners of the companies. And we have a question of a balancing there, the interest in knowing whether shell companies are being used, whether it's to evade taxes or to launder money or to be involved in criminal activities, which have all been revealed by the various leaks that we've had, against the protecting the privacy rights of those people. So these are things we need to discuss and carry on working on. With respect, and that brings me to my second challenge, which is in the context of this question of functions versus positions. I see huge dangers in trying to define who is a journalist and who is a civil society organisation versus who is somebody else exercising their right to freedom of expression or attempting to exercise their right of access to information. That's true in the case of a whole range of freedom of expression rights. But to the extent that we've made progress with the court here on the right of access to information, it hasn't quite yet gone as far as some of the other human rights instances because of that slight limitation in the definition of who may exercise that right. And that's something that we clearly need to discuss more and work on. And then lastly, the strategic question, which I've really covered in the whole of what I've said, which is how do we, as a community, working with the Strasbourg institutions, how do we continue to defend and advance these standards? And let me take one specific example of this Council of Europe Convention on Access to Official Documents. It hasn't got the requisite ratifications. 8 years after it was signed in, it was open for signature and ratification. The Council of Europe simply doesn't have the resources to really make a campaign and to push for that. To what extent can we, as a community, make campaigns and push to get our governments to ensure that the Council of Europe does have the resources? Do we need to be doing the work at the national level to push for ratifications of those treaties? That really the question there is, what are we as a media freedom community going to do in the coming period, where I think we can be pretty sure that the rights to freedom of expression and information are going to come under some very serious pressure? They already are, but I don't think it's going to get better before it possibly gets worse. How are we going to defend these European institutions which have been so important thus far in advancing these rights? Thank you.